Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Kemp v. United States. In this case, the court considered this issue: does Federal Rule of Civil Procedure 60b, 1, authorize relief based on a district court's error of law? The case was decided on June 13, 2022. The court held that the term mistake in Rule 60b, 1, includes a judge's errors of law. Because Kemp's motion alleged such a legal error, it was cognizable under Rule 60b, 1, and untimely under Rule 60c's one-year limitations period. Justice Thomas delivered the opinion of the court, in which Chief Justice Roberts along with Justices Breyer, Alito, Sotomayor, Kagan, Kavanaugh, and Barrett, joined. Justice Sotomayor filed a concurring opinion. Justice Gorsuch filed a dissenting opinion. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. Federal Rule of Civil Procedure 60b, 1, allows a party to seek relief from a final judgment based on, among other things, a mistake. The question presented is whether the term mistake includes a judge's error of law. We conclude, based on the text, structure, and history of Rule 60b, that a judge's errors of law are indeed mistakes under Rule 60b, 1. In 2011, a federal jury convicted Dexter Kemp of various drug and gun crimes, and he was sentenced to 420 months in prison. Kemp, along with 7 co-defendants, appealed. The 11th Circuit consolidated their appeals and, in November 2013, affirmed their convictions and sentences. Kemp did not seek rehearing of the 11th Circuit's judgment or petition this court for certiorari. 2 of Kemp's co-defendants did seek rehearing, which the 11th Circuit denied in May 2014. In April 2015, Kemp moved the U.S. District Court for the Southern District of Florida to vacate his sentence under 28 U.S.C. Section 2255. The government objected that Kemp's Section 2255 motion was untimely. As relevant here, such motions must be filed within 1 year of the date on which the judgment of conviction becomes final. For someone who, like Kemp, does not petition this court for certiorari, a judgment becomes final when the time to seek certiorari expires, ordinarily, 90 days after judgment. This court's Rule 13.1. In this case, the district court concluded that Kemp's judgment became final in February 2014, 90 days after the 11th Circuit's judgment affirming his conviction and sentence, making his April 2015 motion over 2 months late. The district court dismissed Kemp's motion in September 2016, and Kemp did not appeal. In June 2018, almost 2 years later, Kemp attempted to reopen his Section 2255 proceedings under Federal Rule of Civil Procedure 60b, which authorizes a court to reopen a final judgment under certain enumerated circumstances. Rule 60b, 1, permits a district court to reopen a judgment for mistake, inadvertence, surprise, or excusable neglect, so long as the motion is filed within a reasonable time, and, at most, 1 year after the entry of the order under review. Meanwhile, Rule 60b, 6, permits reopening for any other reason that justifies relief, so long as the motion is filed within a reasonable time. Kemp invoked Rule 60b, 6, but his motion arguably sought reopening based on a kind of mistake covered by Rule 60b, 1. Specifically, Kemp argued that reopening was warranted because this court's Rule 13.3 prescribes that the 90-day clock to seek certiorari does not begin to run until all parties' petitions for rehearing are denied, and the 11th Circuit denied his co-defendants' rehearing petitions in May 2014. Thus, according to Kemp, the 1-year period to file his Section 2255 motion began in August 2014, making his April 2015 motion timely. The district court rejected this timeliness argument and, in the alternative, held that Kemp's Rule 60b motion was itself untimely. The 11th Circuit affirmed. While it agreed with Kemp that his original Section 2255 motion appeared to have been timely, the 11th Circuit nonetheless concluded that he had filed his Rule 60b motion too late. The 11th Circuit held that Kemp's reopening motion alleged precisely the sort of judicial mistake in applying the relevant law that Rule 60b, 1, encompasses, and thus was subject to Rule 60b, 1's 1-year limitations period. Kemp petitioned this court for review, and we granted certiorari to resolve the Courts of Appeals' long-standing disagreement whether mistake in Rule 60b, 1, includes a judge's errors of law. Federal Rule of Civil Procedure 60b permits a party to seek relief from a final judgment, and request reopening of his case, under a limited set of circumstances. Under Rule 60b, 1, a party may seek relief based on mistake, inadvertence, surprise, or excusable neglect. Rules 60b, 2, through b5, supply other grounds for reopening a judgment. Finally, Rule 60b, 6, provides a catch-all for any other reason that justifies relief. This last option is available only when Rules 60b, 1, through b5, are inapplicable. Even then, extraordinary circumstances must justify reopening. Rule 60c imposes deadlines on Rule 60b motions. All must be filed within a reasonable time. But for some, including motions under Rule 60b, 1, that reasonable time may not exceed 1 year. Motions under Rule 60b, 6, are not subject to this additional 1-year constraint. Here, the parties dispute the extent to which a judge's legal errors qualify as mistakes under Rule 60b, 1. The government contends that Rule 60b, 1, applies any time a party alleges that a judge has made an obvious legal error, for example, the failure to apply unambiguous law to record facts. Kemp's motion, the government says, alleged an obvious legal error, so the 11th Circuit was correct to apply Rule 60b, 1. According to Kemp, however, Rule 60b, 1, applies only to factual errors made by someone other than the judge. So, in Kemp's view, his motion challenging the district court's timeliness ruling was cognizable under Rule 60b, 6, and the 1-year limit did not apply. We ultimately disagree with Kemp and agree with the government to a point. As a matter of text, structure, and history, the government is correct that a mistake under Rule 60b, 1, includes a judge's errors of law. But we see no reason to limit Rule 60b, 1, to obvious legal mistakes, as the government proposes. We first explain why Rule 60b, 1, covers all mistakes of law made by a judge, and then address why the government's and Kemp's contrary interpretations of mistake do not persuade us. The ordinary meaning of the term mistake in Rule 60b, 1, includes a judge's legal errors. When the rule was adopted in 1938 and revised in 1946, the word mistake applied to any misconception, misunderstanding, or fault in opinion or judgment. In ordinary usage, then, a mistake was not limited only to factual misconceptions or misunderstandings, or to mistakes by non-judicial actors. Likewise, in its legal usage, mistake included errors of law or fact. Thus, regardless whether mistake in Rule 60b, 1, carries its ordinary meaning or legal meaning, it includes a judge's mistakes of law. Had the drafters of Rule 60b, 1, intended a narrower meaning, they easily could have drafted language to that effect. The difference between mistake of fact and mistake of law was well known at the time. Both lay and legal dictionaries identified them as distinct categories. Thus, Rule 60b, 1's drafters had at their disposal readily available language that could have connoted a narrower understanding of mistake. Yet they chose to include mistake unqualified. Similarly, Rule 60b, 1's drafters could just as easily have excluded mistakes by judges from the rule's ambit. In fact, the rule used to read that way. When adopted in 1938, Rule 60b initially referred to as I.e., a party's mistake, so judicial errors were not covered. In 1946, however, the rule's amenders deleted the word his, thereby removing any limitation on whose mistakes could qualify. Thus, as currently written, mistake in Rule 60b, 1, includes legal errors made by judges. Both the government's and Kemp's interpretations of Rule 60b depart from aspects of our reading. Their reasons for doing so are unavailing. The government contends that the term mistake encompasses only so-called obvious legal errors. Several courts of appeals agree that Rule 60b, 1, may be used to correct only obvious errors of law, such as overlooking controlling statutes or case law. The government argues that this limitation has historical roots because courts of equity traditionally could grant relief from legal errors, but only in the most unquestionable and flagrant cases. We are unconvinced. None of the English language or legal dictionaries noted above suggests this obviousness gloss. Nor does the government tie the equity practice it invokes to the text or history of Rule 60b. Finally, we question the administrability of a rule that requires courts to decide not only whether there was a mistake but also whether that mistake was sufficiently obvious. The text does not support, let alone require, that judges engage in this sort of complex line drawing. We are similarly unconvinced by Kemp's arguments for limiting Rule 60b, 1, to non-judicial, non-legal errors. While Kemp does not dispute that mistake ordinarily would cover both legal and factual errors, he argues that the other grounds for relief in Rule 60b, 1, inadvertence, surprise, and excusable neglect involve exclusively non-legal, non-judicial errors, and the word mistake should therefore be similarly limited. But courts have long found that excusable neglect may involve legal error. Because the words surrounding mistake in Rule 60b, 1, do not connote exclusively non-legal or non-judicial errors. They do not favor Kemp's narrower reading. Kemp also argues that Rule 60's structure favors interpreting the term mistake narrowly. Our interpretation, he contends, would create confusing overlap between Rule 60b, 1, and Rule 60a, which authorizes a court to correct a clerical mistake or a mistake arising from oversight or omission whenever one is found in a judgment, order, or other part of the record. We disagree. Because Rule 60a covers a subset of mistakes, for example, clerical ones, whereas Rule 60b, 1, covers mistakes simpliciter, the overlap Kemp alleges would exist even if mistake reached only factual errors. And the courts of appeals have well-established rules for determining when Rule 60a, rather than Rule 60b, should apply. Kemp alleges that our interpretation of Rule 60b, 1, would create a similar problem with respect to Rules 60b, 4, and b5, which authorize relief from voided judgments and judgments that lack legal effect. Specifically, Kemp contends that a legal mistake could warrant relief under both Rule 60b, 1, and Rule 60b, 4, or Rule b5, and a conflict could then arise given that the latter rules are not subject to a one-year time limit. But, again, that could occur even if only factual errors count as mistakes, since factual errors, too, may justify relief under Rules 60b, 4, and b5. And, regardless, should this overlap ever create an irreconcilable conflict, courts may then resort to ordinary rules of statutory construction when selecting which provision would govern in a particular case. Kemp also worries that our interpretation would allow parties to evade other time limits set forth in the federal rules. For instance, Rule 59e motions to alter or amend a judgment must be filed within 28 days, and appeals must generally be filed within 30 days. Kemp suggests that our interpretation would allow someone to repackage a tardy Rule 59e motion as a timely Rule 60b, 1, motion, or to generate a right to an untimely appeal by filing a Rule 60b, 1, motion and appealing once it is denied. We are unpersuaded because, yet again, the risk Kemp identifies would exist even under his own interpretation. For example, Kemp provides no explanation why, under his interpretation of Rule 60b, parties could not repackage tardy Rule 59e motions based on legal errors as motions under Rule 60b, 6, or recharacterize tardy motions based on factual errors as motions under Rule 60b, 1. A denial in either case would then permit the litigant to appeal outside Appellate Rule 4's 30-day time limit. In any event, the alleged specter of litigation gamesmanship and strategic delay is overstated. Rule 60b, 1, motions, like all Rule 60b motions, must be made within a reasonable time. And while we have no cause to define the reasonable time standard here, we note that courts of appeals have used it to forestall abusive litigation by denying Rule 60b, 1, motions alleging errors that should have been raised sooner, for example, in a timely appeal. Nor, contrary to Kemp's protestations, is our interpretation inconsistent with the history of Rule 60b. Kemp points out that Rule 60b, 1, drew its text from existing state procedural rules. And he argues that its list of grounds for reopening, mistake, inadvertence, surprise, and excusable neglect was understood when Rule 60b was adopted to be a term of art that excluded legal errors. But while some states interpreted their rules this way, others, like California, did not. Moreover, at least one leading treatise from the era maintained, consistent with our view, that mistake encompassed legal errors. Although statutory language obviously transplanted from another legal source will often bring the old soil with it, that principle applies only when a term's meaning was well settled before the transplantation. Here, it was not. Finally, Kemp invokes Rule 60b's 1946 amendments replacing bills of review and other traditional, post-judgment reopening mechanisms with Rules 60b, 2, through b6. He argues that Rule 60b, 6, alone was intended to afford relief for judicial legal errors that had previously been remedied by bills of review, because such errors were not cognizable under Rule 60b's mistake provision or its predecessor state rules prior to the 1946 amendments. But, as noted, the pre-amendment Rule 60b covered only a party's mistakes, and for that reason could not be grounds to correct a judge's legal mistake. By eliminating that party-specific qualifier, the 1946 amendments open Rule 60b, 1, to judicial mistakes of law previously remediable only by bills of review. In sum, nothing in the text, structure, or history of Rule 60b persuades us to narrowly interpret the otherwise broad term mistake to exclude judicial errors of law. Because Kemp's Rule 60b motion alleged such a legal error, we affirm the 11th Circuit's judgment that the motion was cognizable under Rule 60b, 1, subject to a one-year limitations period, and, therefore, untimely. It is so ordered. Justice Sotomayor, concurring. I join the court's opinion holding that the term mistake in Federal Rule of Civil Procedure 60b, 1, encompasses a judge's mistake of law. I write separately to make 2 points. First, I join the court's opinion with the understanding that nothing in it casts doubt on the availability of Rule 60b, 6, to reopen a judgment in extraordinary circumstances, including a change in controlling law. Today's decision does not purport to disturb these settled precedents. Second, I do not understand the court's opinion to break any new ground as to Rule 60c, 1, which requires that all Rule 60b motions be made within a reasonable time. Justice Gorsuch, dissenting. The court took this case to determine whether a district court's mistake of law is correctable under Federal Rule of Civil Procedure 60b, 1, or 60b, 6. From the start, granting review was a questionable use of judicial resources. The answer matters only under rare circumstances. A losing party fails to appeal or secure relief under Rule 59e, opting instead to file a Rule 60b motion. That motion comes more than a year after judgment but, piling contingency on contingency, within what the court would otherwise deem a reasonable time. By petitioner's own, uncontested, count, his is the first petition ever to present today's question for this court's review. Beyond even that, an alternative route exists to resolve the question posed here. Congress has adopted the Rules Enabling Act. Under its terms, a committee composed of judges and practitioners may recommend to this court any warranted clarifications to the Federal Rules of Civil Procedure. Those recommendations generally take effect upon our approval and absent congressional objection. Undeterred, the court takes up and resolves this case anyway. It holds that Rule 60b, 1, not Rule 60b, 6, applies. In an unexpected twist, the court adopts a further position neither party saw fit to advance. Going forward, every judicial legal error, not just an inadvertent or obvious mistake, is fodder for collateral attack under Rule 60b, 1. And what is the basis for all this? A mysterious 1946 amendment deleting the word his. Respectfully, I would have dismissed the writ of certiorari as improvidently granted. Not only does this case fail to meet our usual standards for review. At bottom, this dispute presents a policy question about the proper balance between finality and error correction. Should a district court be able to clean up a legal error through a collateral proceeding on any reasonable timeline within a year of judgment? Or do Rule 59e and the appellate process provide the necessary corrective measures in ordinary cases, with Rule 60b, 6, as a last, narrow avenue to relief? Questions like these are best resolved not through a doubtful interpretive project focused on a pronoun dropped in 1946, but through the rulemaking process. There, policy interests on both sides can be accounted for and weighed in light of the collective experience of bench and bar. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please go to the podcast's website. It's at anchor.fm/SCOTUS-opinions/support. Again, the website address is anchor.fm/SCOTUS-opinions/support. There you can also see other episodes and send a message to me, the podcast's creator. Thank you.